So we just got some huge news. The Supreme Court just issued their decision in the Cargill bump stock case. It is a 6-3 decision authored by Justice Thomas, and it's a decision striking down the ATF's bump stock ban. Not only has the ATF lost this week in their issue about private party, transactions, they're engaged in the business rule. Then yesterday they lost in their pistol brace rule, and today they lost big in the Supreme Court. It's a 6-3 decision against the ATF against bump stocks. So let's take a look live at what's going on with this decision. Kind of the first time we're looking at this, I'm going to break this down, and then later we're going to do a more comprehensive video, so check that out for later today. Now, really quick before we jump into breaking down this decision, I want to ask you guys for a huge favor. Looking at some of my analytics, a bunch of you are actually not subscribed to the channel. We've actually reached over 700,000 subscribers, but I would love your guys' support. So if you enjoyed this content, please like the video, subscribe to the channel, and then also make sure you're sharing this video. This is very important for every single gun owner. So if you know a gun owner, share this video, share it to them so they get this information, so they know what the Supreme Court just said about the ATF's bump stock ban. So if you just want the basic holding of what the Supreme Court did in this decision, you have the first syllabus section, and it simply says held. ATF exceeded its statutory authority by issuing a rule that classifies a bump stock as a machine gun under section 5845 subsection B. So they stated that essentially the ATF exceeded their authority, like we said all along, by promulgating this bump stock rule and saying that bump stocks on their own are machine guns. The Supreme Court, Justice Thomas in this opinion said, nope, the ATF, you are incorrect. You exceeded your authority and we're striking down your bump stock rule. And then it goes on to A semi-automatic rifle equipped with a bump stock is not a machine gun as defined by that section because 1, it cannot fire more than one shot by a single function of the trigger. And 2, even if it could, it would not do so automatically. ATF therefore exceeded its statutory authority by issuing a rule that classifies bump stocks as machine guns. Again, something we said all along, the ATF's definition, they kept trying to say by a single function of the trigger, single pull of the trigger, all of these things that they were trying to change some of the definition language to meet their needs of banning bump stocks, to treating them as machine guns. The Supreme Court said, no, that is not how that works. Again, you exceeded your authority. Then they go on to say it's in subsection B, a semi-automatic rifle equipped with a bump stock does not fire more than one shot by a single function of the trigger. The phrase function of the trigger refers to the mode of action by which the trigger activates the firing mechanism. No one disputes that a semi-automatic rifle without a bump stock is not a machine gun because a shooter does not release and reset the trigger between every shot. And any subsequent shot fired after the trigger has been released and reset is the result of a separate and distinct function of the trigger. Nothing changes when a semi-automatic rifle is equipped with a bump stock. So again, something we've said all along, simply just putting this piece of plastic on a semi-automatic AR-15 does then not magically make it a machine gun under the statutory definition. All along, also, the ATF was trying to say that this single piece of plastic in its own right was a machine gun, could be regulated, and then also putting it on that rifle made that semi-automatic rifle suddenly a machine gun. And that was the ATF's position, and the Supreme Court here is saying, no, that's incorrect. They go on to say a bump stock merely reduces the amount of time that lapses between separate functions of the trigger. So again, here they're saying that, again, the bump stock does not mechanically change anything. This is something we also saw the Fifth Circuit talk about quite often. The Fifth Circuit en banc panel, when they struck down the ATF's rule, they went through the mechanics of what a bump stock really does. They went through the mechanics of a firearm with a bump stock attached, and they showed that it doesn't change the trigger mechanism or anything like that at all. It simply just, again, changes that lapse of time. It just helps you shoot a little bit faster, but that's not what the statute is concerned about. The statute talks about resetting of the trigger and things of that nature. It does not actually contemplate bump stocks here. So the ATF then trying to promulgate a rule to regulate these items goes clearly beyond their authority. Now, one of the things I also want to note here is a lot of people might say that this is a Second Amendment decision. We all know that, at least if you've been watching my channel, this is not a Second Amendment decision. This is more of an agency decision. It's more about overreach, APA violations, and things of that nature by the ATF. What authority did they have to issue this rule, to have this final rule, and to regulate these items? It's more concerned about that, not necessarily the Second Amendment. But we have another decision coming soon in the Rahimi case, which is a direct application of the Second Amendment of the Bruen decision when it comes to federal restrictions on things like people in possession of firearms if they are subject to a domestic violence restraining order. The Supreme Court then goes on to say in subsection D that in the ATF's view, Congress restricted machine guns because they eliminate the manual movements that a shooter would otherwise need to make in order to fire continuously at a high rate of fire as bump stocks do. So ATF reasons concluding that bump stocks are lawful simply because the trigger moves back and forth would exalt artifice above reality and enable evasions of the federal machine gun ban. That presumption, the presumption against ineffectiveness, cannot do the work that the ATF asks of it. Interpreting section 5845B to exclude semi-automatic rifles equipped with bump stocks comes nowhere close to making the statute useless. And then it says that the opinion was issued by the great Justice Thomas. So again, Thomas comes through. Thomas was joined by Chief Justice Roberts, Alito, Gorsuch, Kavanaugh, Barrett. I'm glad that Roberts and Barrett joined this opinion. And then Alito wrote a concurrence, but he's still in the majority opinion as well. And then you have Sotomayor in the dissent, who wrote the dissent, which was joined by Kagan and Jackson. So this is a 6-3 decision, once again authored by Justice Thomas, striking down the bump stock ban. Now, I'm probably going to do a much more comprehensive video down the road. I just want to get this information out to you guys. The Supreme Court has issued their Cargill decision. They have struck down the bump stock ban. They found it was beyond the ATF's authority, that the ATF overreached. And this is a striking blow to the ATF and their regulation. Now, if the ATF could not protect their bump stock ban, which if you listen to those arguments, it was iffy. 6-3 came through in our favor. And now when you're looking at things like the Vanderstock unfinished frames and receivers rule, the pistol brace rule, the engaged in business rule, all of these that have already been struck down by the lower courts, it is not looking good for the ATF. So amazing news. Go support Michael Cargill, the plaintiff here in this lawsuit. Go support everybody who is involved in this lawsuit. Amazing news. I will get you guys more information. And again, keep an eye out for my video later on today. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.